thank you for being here. Welcome to the Florida Supreme Court Judicial Nominating Commission. Thank you for traveling. Well, I guess maybe you didn't travel far, but at least interrupting
1.3 miles.
Interrupting perhaps holiday plans. We appreciate that. We always start these interviews by allowing the applicant to make a brief opening statement, either introducing yourself or highlighting whatever you want to about your candidacy.
Okay. Well, thank you. And thank you all for your work. I know it's been a ton in a very compressed time period, so I'm grateful for all the attention and effort that's gone into it. When I interviewed before the 2nd District Judicial Nominating Commission and when I was last before this commission, my pitch was substantially this, and I think it's going to be the same today. I think the most important thing that any appellate judge does, and that includes a Supreme Court justice, is to produce opinions that correctly ascertain a generally applicable legal principle, justifies it with analytical rigor, thorough research, and an honest statement that accounts for objections. I think that is the rule of law in action. And I think that is how individual dignity and individual liberty are preserved. People are regarded as formal equals, and they are expected to have the entitlements and obligations that either they, through the Constitution, or their elected representatives through legislation, have agreed to. And I think it's the way you get economic prosperity. When individuals and businesses know that the law as stated is going to be the law as applied, they have the confidence to make investments in themselves. I believe that, and I think my work on the 2nd District exemplified that. I'm particularly proud of my work in statutory construction cases, which I've highlighted in the application. I am proud of the fact that when I believed that the 2nd District had gotten it wrong on those issues, I was able to raise it and persuade people to correct it, and I would take the unanimous en banc decision in Burgess versus State as an example. I would also take my concurring opinion in JC versus State, which was picked up by the 3rd District, as an example. That motivated me. It still motivates me. In 2020, I was at a place where I really wanted to contribute more in a way that would be more broadly consequential. I had at that time believed that I really didn't have a path to do that in the branch, although that is, I think, my highest and best use, and also was presented with an opportunity to work with values-aligned people in a way that I could make that contribution differently, either through kind of the cases we decided to fund or having the kind of flexibility to get involved on issues that are important to me. I made that move. That is kind of how it played out. I started doing amicus briefs in free speech cases with Alliance Defending Freedom, which I think importantly advanced the ball on principles. Gradually decided to move back to appellate practice full time, and I've been able to do some things there that I think have been important. I would highlight my work on the Hillsborough County transit tax referendum, which I think was a case of the government just being dishonest with its citizens. My work for Jerry Torres, which produced an opinion that at the end of the day had kind of put the kibosh on political adversaries using minor qualifications, failures to get people kicked off the ballot. When Lawson Huck opened, I was able to move there and continue doing those kinds of important consequential things. I've attached 2 examples as my writing samples to the application. I didn't expect to have this opportunity. I'm grateful for you giving me the chance to talk about it. But I really do think that my work as a lawyer, that is to say what my aptitudes are, and my interpersonal skills make this potentially my highest and best use, and that's why I'm here, and I thank you for giving me the chance to talk about it.
Well, thank you very much. Commissioner Serio.
Good morning, Mr. Salario.
Good morning.
Thanks for being application. And you are obviously known to several of us on this commission. You've been around a long time. You have a tremendous track record. And so the vetting, there were no surprises in the vetting. Just you are very highly thought of around the state. And so we're glad to see your application and glad to be with you this morning.
Thank you.
One of the things that you definitely touched on it in your comments, and I think it's the question that I wanted to ask. You have a stellar career in private practice, both before going on the second, after you left. After the second DCA, you had a tremendous career as a judge on the second DCA. You talked about why you left. Makes sense. Why do you want to come back now at this time? What can you contribute to this court, Mr. Salario?
Well, I think, the reason I want to come back, I think I alluded to in my opening, which is, and I think if you look at my body of work on the second district and my body of work as a lawyer, I hold myself to a very high standard of thoroughness and analytical rigor. I think that's critically important in a Supreme Court justice. I think that I have that to contribute. And I think I have a set of interpersonal skills that make me productive on a multi-member court as an advocate for what I perceive to be the correct way of doing things.
Great answer. Thank you, sir.
Thank you very much. So where does that take us? No. Commissioner Barrett.
Yeah. Thank you, Mr. Chair. Judge, it's great to see you. I was excited to see your name in the applicant pool. Thank you. I know what effort it took to do that, and appreciate you being here. Let me ask you this. Let's talk. We'll come back to our favorite topic of the day, stare decisis. Let's say in the course of deciding a case that was before you, you came to believe that an issue was wrongly decided in the past. What sort of considerations would be important to you in deciding whether to adhere to a wrongly decided precedent or in receding from that precedent? And considering those factors, what weight would you assign them?
So what would be important to me is actually tying stare decisis to some clear doctrinal underpinning. I don't think the problem I'm about to describe is unique to stare decisis. I think it's endemic to a lot of doctrines that regulate kind of how do appellate courts deal with themselves. But I think, we don't really have a clear answer. Like, is stare decisis something that flows from the judicial power? Like, is it a limitation on the judicial power, or is it a matter of judicial discretion and how we regulate ourselves as a branch? And I'm a little embarrassed to say I listen to Supreme Court oral arguments while I'm working out, but if you listen to the argument...
Slow workouts.
Primarily for pointers on how to be an advocate, but also because they're interesting. And if you listen to the argument in Slaughter, which is the Humphreys executor case, I think you can really hear, like, even the justices, I don't think have a clear, just if you listen to the kinds of questions they're asking that touch on the subject, have a clear doctrinal tether to what the doctrine flows from. And on that, I think Justice Thomas's concurrence in Gamble versus United States is super helpful and super persuasive. And basically, the way he frames it is, look, stare decisis evolved in a common law system where judges announce law. We now live in what is predominantly a positive law system where law is given by the Constitution or by the legislature. When we've gotten that demonstrably wrong, like it is just an abuse of the judicial power to allow it to persist. In other circumstances, kind of pure common law circumstances, you would say the court has discretion to correct an error and to consider things like reliance interests workability, but where you're dealing with positive law, you have the obligation to correct a demonstrably wrong decision. I think that leaves kind of two questions. One is, what is demonstrably wrong in a universe where if you're applying an originalist or textualist methodology, there really ought to be only one right answer, so by definition, the wrong answer is demonstrably wrong? And two, how do you build something that endures, right? In other words, if you assume that that's going to be it, and, you know, I think this works better in the Supreme Court that's always sitting on bonk, but like if you assume that that's going to be how you do it, how do you make sure that what you are doing is sustainable? And I think the answer to that is the analytical rigor and honesty of the opinion, and then some institutional checks. One institutional check are the political branches, that is to say, you count on your elected representatives to appoint people who do the thing correctly. Another institutional check are limitations on the number of cases that an apex court can take. The Florida Supreme Court's jurisdiction is entirely discretionary for most cases, and they can only take, and they have to fit into pretty narrow constitutional categories. So just by virtue of how the system works, if you've done the opinion right, it should be able to persist.
Great, wow, that's very thoughtful. I'm sure there'll be some follow-ups to that. I'll defer the further commissioners. One, just zooming out, you know, looking back, you know, we've obviously gotten a bit from you about your decision-making to get to this point. Looking forward, you know, 10, 20, 30 years out, looking back on your career if you're appointed, how will you know whether you were a good Florida Supreme Court justice? What's your measuring stick?
I think my metric stick is what I said my value proposition was. If I can look back over a body of opinions and say, I got that right and I did it the right way, I'll have done my job correctly.
Thank you.
Thank you. Commissioner Sammer.
Thank you, Chair Panuccio. And Mr. Salario, very good to see you again. And I want to thank you again for your service. I think one of the things that was clear to me in having had the opportunity now to vet you in this process again, although I wasn't the primary vetter, is that your opinions from your tenure on the second DCA, which was a very distinguished one, still resonate, including the example that you mentioned a moment ago in the third DCA actually adopting one of your concurrences. I know you've also had, in the last several years, a really distinguished practice, once again. My question for you really centers around the work that you've done now over the last few years. You previously would have been called to provide an objective view and assess a case, and now, as counsel, you're advising your clients on the merits of their cases, but also on the strategies for advocacy. So if you as counsel or as an objective observer, let's say, or an interested observer, but one who's called on to be objective, were evaluating a case in which Judge Salario were on the panel, what kind of advice would you give your client about how to frame the advocacy, given what you as an objective observer know about Judge Salario? What kind of judge would you say Judge Salario was and will be?
So I think maybe a couple of points in response to that. To the extent we're talking about a case that hinges on a question of statutory or constitutional interpretation, you know, it is textualism, like found your arguments in the text, and that's very much what I try to do in practice, by the way, whether it's a statute or a contract. Like, my briefs always have a section called text and a section called context, and that's the way I would tell the person to argue to me. And the reason I kind of highlighted is it did kind of surprise me that when I was on the court, like how often briefs don't do that. The other thing I would say is, like, be analytically disciplined. Point A linking to point B, linking to point C, and a cohesive argument. I mean, I guess one thing, and maybe a third thing that's unique to me is, or not unique, but maybe atypical to me is, like, I just, as a matter of mental habit, have a hard time with individual trees if I don't understand forest. So I need to make something fit into the broader scheme of things.
Thank you.
What would you say putting aside legal doctrinal issues at the Florida Supreme Court, I don't want you to opine on potential legal cases, but looking to the other work of the court, so the administrative work, the management of the branch, the management of the bar, overseeing rules, attorney discipline, any of those areas, what would you say are the most critical issues facing the Florida Supreme Court? What is your vision for the direction of those issues, and what are your qualifications to move that vision forward?
So I'll start with the last part of the question first, which is what are the qualifications? And I think I've kind of demonstrated during my time on the second district the ability to do that. I mean, I think it is true in any institution, but particularly true in government institutions and courts, that, you know, asking the question, why do we do this way, is very important, and very often the answer is just kind of the reason we do it this way has been lost to history. And so I think the predisposition to ask that question and then to follow through on it, and I can give two examples. I kind of felt during my time on the court that the way we were handling oral argument was we were hearing argument in a lot of cases that didn't need it, and weren't hearing argument in a lot of cases that did need it, and that had to deal with, like, we would always hear argument in final judgment cases, but was very hard to get it on like a non-final or a cert. I led an internal committee that revised the oral argument policy, and we now, or the court, when I left and still does, have a system where if you ask for oral argument, you presumptively get it, and then the panel kind of makes a decision as briefing gets perfected and everything. Okay, do we really need this? And we can take off cases that we don't really need argument on. You know, another was on the way the court processed stand your ground cases. Those typically came up through a motions panel, which is not the most focused, disciplined way to make a decision about a thing. There's no primary judge assigned to it that is worked up by a staff attorney. You know, I kept seeing orders post the 2017 amendments, which to me were significant, and I mean, you can debate it as a matter of policy, but it wasn't unclear, that kind of deviated from what the statute was. And I kind of went to central staff and the chief judge and was like, listen, we need to start doing this a different way. So the way that they are processed now gets a lot more focus and attention on them. So I think, by way of answer to the qualifications question, it's the question I asked and kind of historical evidence of dealing with it. In terms of the biggest problems facing the branch right now, I mean, I do think that the per curiam affirmance presents disadvantages that far outweigh the advantages of the status quo system. And I can talk about that more if you want, but that's kind of the top line. And I kind of have this whiteboard idea of, you know, is there a way to limit PCAs to cases where there's really no issue of arguable merit, and then have a, you know, for cases where you don't want to create too much law, the issues haven't been presented well, whatever other reason, you might have a truly unpublished, non-precedential decision that balances conserving judicial labor with giving the parties some summary explanation of why the case has been decided the way it's been decided. You know, so that would be kind of one thing that resonates in my mind, and I've seen that on both sides of it. I think, you know, just the courts generally face a credibility crisis because of political attacks on the branch. I think what the Supreme Court can do is limited on that. I mean, it can't control the social media environment. It can't control the way reporters report on the work of the courts. But it can, by making quiet, disciplined, justified decisions without fanfare, and then being accessible to the public to explain the work of the courts, I think blunt that credibility problem that's just kind of endemic to where we are as a culture right now.
Thank you. Commissioner Tate.
Well, you took my question, but I'll.
I'm sorry.
think of another one.
You want me to go to Commissioner Karlinski? and
No,
come
I
back?
think
Okay.
I'll first of all, just say that I couldn't be more impressed with your application and your references. Extremely well done.
Thank you.
Let me just follow up on your answer to that and ask you, when you were on the second and maybe projecting if you were able to get this appointment, when would you decide to write about a decision that was before you versus PCAing or allowing another member of the court to write?
Yeah, so I think those are slightly different answers. So maybe, yeah, like, are you interested in kind of how I view the decision to PCA versus right?
Yes, sir.
Yeah, so I will tell you the thing that concerns me most is, and I was not an appellate practitioner when I went on the second, so this was something I kind of had to figure out over time and didn't really get. But I think that there are statistically significant number of per curiam affirmances that are based on either procedural defaults or alternative grounds to affirm, that if you mention them to the parties who briefed and argued the case, they would be surprised. And I think that that is my kind of my core concern with the device, like what I think is the biggest problem because of the procedural fairness implications that flow from it. So I think, you know, if I had it to do all over again, I would write uniformly in those kinds of cases. I think cases where the parties have done a sloppy job of presenting issues, or, you know, or there's just really nothing to add to the law, you know, you might handle with a citation PCA or a very short opinion that kind of balances the, you can't write on everything with, or by the way, if the trial court just got it right for the reasons the trial court gave in the order it wrote, you know, you might balance that with something very short that explains that.
Thank you.
Thank you. Commissioner Karlinski.
Thanks, Mr. Chair. I was actually going to ask about PCA, so I'm good.
Okay. Vice Chairman Stearns.
Good morning. I recall being on your interview panel for vacancy in Tampa 13 or 14 years ago. So congratulations on an impressive career. You discussed the why in your opening, but what assurances can you provide this body and the governor that if you're appointed to the Supreme Court, you won't suffer from that feeling that you don't have a path to contribute and resign your seat?
This is, to me, the highest contribution I could possibly make. You know, I mean, I am a Florida guy. This is the Florida Supreme Court. It's the highest place you can get in the Florida branch. I don't have anything else that I'm particularly dying to do. I am, you know, financially stable, so all of this works for me, and I just can't think of any kind of greater service I could perform that aligns with what I'm good at and what I can contribute to the state.
Thank you.
Any other commissioners have another question? Okay. Is there anything that wasn't disclosed to the commission through your application or otherwise that we would need to know because it might cause any kind of embarrassment to the commission, to the governor, to the judiciary, or the people of the state if you were nominated or appointed to this
No,
position?
sir.
Okay. Thank you very much for your time. Appreciate you being here.
Thank you very much.